So basically, what is 125 CRPC? It is about provision of maintenance. Am I audible?
Yes, ma'am.
So we are starting today maintenance under section 125 CRPC. So how many of you have attended the provisions of Domestic Violence Act? The session which I had given to you, Domestic Violence Act. How many of you had attended? Just give me a thumbs up. Only one person. Okay. Basically, 125 of Criminal Procedure Code says about order for maintenance of wives, children, and parents. 125 clause 1 says if any person having sufficient means and neglects or refuses to maintain, to whom? To his wife who is unable to maintain herself. Secondly, illegitimate or legitimate minor child. Legitimate or illegitimate child not being a married daughter or who has attained the age of majority. Basically, up to yet I have told you a person who is having sufficient means and denies to maintain or avoid to maintain to his wife who is unable to maintain herself, or legitimate or illegitimate minor children. Legitimate or illegitimate child, it should not be a married daughter. It should not be a married daughter. And if he or she has attained the age of maturity, in that case, why a person will maintain that child? If the child is by any reason like physical, mental abnormality, or any kind of injury, he is unable to maintain herself. Basic point is that a person who is having sufficient means and is avoiding to pay maintenance to his wife, to legitimate and illegitimate minor children, legitimate or illegitimate children, who कौन से बच्चे? We have already stated about minor children who had attained the age of majority. Now the question arises, why a father will pay maintenance or give maintenance to the children who has attained the age of majority? There are three provisions. First of all, if that major child is mentally, physically abnormal, or is abnormal or is unable to maintain herself or himself due to injuries. Only in that case, major child is entitled to get maintenance. But again, main provision is that that major child should not be a married daughter. Okay. Next, father, mother, even they are also eligible to get maintenance from their son. Provision is same, not provision, we can say process is same basically. In such type of cases, like complaint or petition is used to be filed in family court under section 125 CRPC along with the sporting affidavit. Therein we have to mention all kind of facts, why he is not paying, and why I'm I want to get maintenance, or why we need maintenance from him, why he is not paying, what is the issue. Basically, we have to mention all kind of facts to get the maintenance from husband, even father, mother, brother. So when a wife files a petition under section 125, she will have to make it clarify that she is not avoiding her liabilities. Also, she is unable to maintain herself. Likewise, I told you in the domestic violence complaint. Also, she will have to clarify that why she doesn't want to reside with her husband. There is condition. If the husband states that I want to reside with my wife and want to consume my married life, and wife denies without any genuine reason, then the court can dismiss her petition. As far as father and mother are concerned, what is the definition of father and mother? You can say basically what is the definition of parents. Parents can be natural parents, parents can be adoptive parents. As far as wife is concerned, even divorced wife is also liable to entitled to get maintenance, but condition is that she has not got remarried. Till now everything is clear.
Yes,
समझ में
ma'am.
आ रहा समझ में आ रहा है?
Yes, ma'am.
Okay. So when we are used to file a petition under section 125 along with sporting affidavit and sporting documents, likewise a complaint under section 12 of domestic violence act, I had stated to you that an affidavit of income and assets is also used to be filed by the both parties, means husband and wife. In this case you can say uh, both parties, maybe husband wife, maybe brother sister, maybe parents and son, maybe wife and husband, because husband can also get maintenance from his working. So in these cases, uh, affidavit of income, assets and expenditure is also used to be filed. As far as interim order is concerned or final order is concerned, the court can pass the order of the maintenance from the date of order or from the date of filing of the application. But as of now, as per latest judgment of Supreme Court, I'll tell you the name of the judgment, title of the judgment, because I have not prepared for today. But still, because I don't want to waste your time, I'll tell you the name of the judgment. As per that particular judgment, it is the duty of the court to pass the order of maintenance since the date filing of the application. Since the date of filing of the application, the maintenance will be allowed from the date of filing of the application. However, it is in the law itself, CRPC 125 says itself, but most of the times court were used to pass the order that so and so amount will be handed over or given to the to the petitioner as maintenance since the date of order. Is in what was scenario at that time? If I had filed any application on behalf of the complainant or petitioner in the year 2017 and interim has been decided in the year of 2021, then what about those 3 years? What about those 3 years? I didn't get the relief, na? Even I'm maintaining myself, I'm maintaining my children, I'm paying a lawyer fee and other miscellaneous expenses. From where I will bring it? So, to cope up with this situation, the Supreme Court has passed that particular judgment wherein the clear directions are to the judiciary that the order should be given, order should be passed with regard to maintenance from the date of filing of the application. Secondly, it is the duty of the counsel, it is the duty of the advocate as well to press upon this particular point that the order should be passed from the date of filing of the application instead of date of the order. Many times we are used to be a normal, lenient, and court is also used to be lenient. Okay, I'm going to pass the order from the date of order. But if the counsel will press the honorable court by mentioning the genuine reasons, then the court will have to pass an order that the maintenance should be paid from the date of filing of the application. Got it? Again, the procedure is same. After filing the petition, the court will issue summons to the opposite party. The respondent will come to the court, and court will ask, "What do you want? You want to reside along with your wife, or will ask you whether you want to live with your husband? What is the issue?" And the court is used to send the matter to the mediation center to mediate and settle their respective disputes. The process is same because it is family matter. Many times, in such kind of cases, the mediation gets failed because parties are too reluctant that नहीं नहीं मैं तो इसको मजा चखाऊंगी मुझे इसने कैसे पैसे नहीं दिए मुझे इसने कैसे खर्चा नहीं दिया even I'm sorry to say we lawyers are also used to pin up to the clients कि नहीं मीडिएशन में कुछ नहीं रखा है यहाँ से मैं तुम्हें ये दिलवा दूंगा वहां से मैं तुम्हें ये दिलवा दूंगा बट my my view is different. However, I'm also a practicing lawyer, but my view is different. My view is that if both the parties are getting agreed for mediation and your matter is getting settled there in the mediation, then why you are getting the matter linger on in the court? In the 19 year of my practice, I have noticed this thing. Cases gets linger on year to year, and ultimately both the parties, we can say, well, at the last stage feels embarrassment कि why we had filed the case, why we had wasted our time. हम mediation में चले जाते हम settle कर लेते अभी ये time हो गया वो हो गया and ultimately they are used to abuse to the councils. So it's much better if you think your matter, your case is getting settled in the mediation, there is even a single chance, let them mediate and you will have to support them. Now, your question will be what will be the benefit of a lawyer? Maybe monetary benefit should not be with you or maybe with you, but a mental peace with you. You will get a mental peace. Why? Because of you, your efforts, family has been avoided to be spoiled. एक रिश्ता बच गया, एक परिवार बच गया. Besides that, that particular client will tell to their known to that so and so lawyer is very good. At initial stage, as I had told you earlier, at initial stage of your practice, don't think about money, don't think about fee. Do work hard, get name, fame will come to you. Even after a having experience of 19 years till today, I'm also doing such kind of things. I have so many cases wherein I have done mediation myself. And in my cases, I think, if I can say not 100%, but 99%, in 99% cases, I have settled their disputes out of the court. And ultimately, by giving the statements in the court, they had withdrawn their cases, and now they are very happy in their life. And till today, I am into contact with them. So टॉपिक से थोड़ा सा हट गई थी मैं. We were discussing about 125. So these are the basic things of 125. And if there is only issue of maintenance, if there is only issue of maintenance, there is no other cruelty or nothing, then you can state them, you can open them that अगर आपको मेंटेनेंस फिक्स हो जाता है, मिल स्टार्ट हो जाता है मिलना, then are you ready to close the case? What will be the benefit? The benefit will be, if she is in need of only maintenance, she will get the maintenance. My motive was to get her to maintenance from her husband or her father or her brother. Okay, with this particular order, your lordship, this and this is her demand. He is ready to pay. Okay, order karo, छुट्टी, बात खत्म. Don't linger on the process. Basically, for females, besides 125, I had already told you, domestic violence is also there, wherein she can claim the maintenance. And in other proceedings like divorce petition or restitution for conjugal rights, she can claim interim maintenance under Section 24 of Hindu Marriage Act. Maintenance pendente light, which means interim maintenance till the pendency of the case. As far as parents are concerned, they can claim under Section 125 CRPC. Mother can claim under Section 12 and 20 of Domestic Violence Act. If she is senior citizen, she can claim maintenance under Welfare and Maintenance of Senior Citizen Act. As far as children are concerned, they can claim maintenance under DV Act through their mother or natural guardian, under Section 125 through their guardian, Maintenance and Guardianship Act through their guardian. They can claim the maintenance. So up to yet you have gone through You had got whatever I have stated to you. सब समझ में आया जो अभी तक मैंने बोला? So I'll discuss on this topic tomorrow also as an explanatory, and tomorrow I'll try to cover welfare and maintenance of senior citizen also. I'll cover two topics tomorrow because I think thereafter there will be two topics pending. One will be RERA and one will be uh, let me check. Tejas, can you tell me plea bargaining? I think plea bargaining. So tomorrow we will discuss 125 as whole with the judgments and uh, maintenance and welfare of senior citizens. And day after tomorrow we can discuss about RERA as well as plea bargaining. Okay. So up to yet you got what I have stated to you.
Yes, ma'am.
So I'm not in a good position.